Welcome to the deep dive. So, there's been quite a bit of buzz lately, around a big Supreme Court decision.
Mm,
And like often happens, the first stories, the initial media narrative, well, it can sometimes point us down an interesting path, but maybe not the right one.
absolutely. When this news first dropped, a lot of people, and yeah, even some very seasoned legal folks, thought, okay, this is it.
The big one on birthright citizenship.
Exactly. That seemed to be the assumption of major ruling on the constitutionality of the 14th Amendment, all of that.
But, and this is the crucial point we need to get into right away for you.
Yeah, the court didn't actually rule on that specific issue. Not at all.
Right. So while birthright citizenship was, part of the case originally,
It was the backdrop, definitely.
the justices decided to focus elsewhere entirely.
Which brings us to the real subject of this deep dive.
Exactly. What they did rule on, it's about this less flashy, maybe, but incredibly powerful tool that lower courts use.
Uh-huh. The nationwide injunction.
That's it. And our mission today is really to unpack why this seemingly technical legal thing is actually a huge deal.
It really is. It shapes federal policy, impacts the whole country, and involves this complex balance of power.
Yeah, these aren't just like minor legal points. We're talking about the power for a single judge, potentially, to freeze a federal policy everywhere.
A huge power. Creates real tension with the executive branch. It's got a fascinating history, too, or lack thereof, for a long time.
So setting the scene again, the initial focus, and we saw this in some of our sources too, was squarely on birthright citizenship. Lots of anticipation.
The whole 14th Amendment question. Does it compel birthright citizenship? That was the expected debate.
But then, the surprise turn. The court just sidestepped it.
Completely. The core issue they tackled instead was, like you said, the power of these district judges to issue those sweeping nationwide orders.
One commentator basically said that the case became this other thing. It shifted from the policy itself to the scope of judicial power.
Which is interesting in itself. And, another observation from our sources was that this year's SCOTUS docket feels a bit different.
How so?
Less like every single case is, democracy itself hangs in the balance compared to maybe last year.
Ah, okay. More like a return to the courts, sort of regular business.
Maybe. Focusing more on the mechanics of law, the procedures, the checks and balances within the system.
So let's get to the decision itself. How did the court rule on these nationwide injunctions?
Well, it was a 6-3 decision.
Yep.
And they granted what's called a partial stay on these injunctions.
A partial stay. And that's seen as a win for the Trump administration.
Oh, definitely. Widely interpreted that way. They've been pushing back hard against these kinds of broad orders.
So why? What was the court's thinking here? Why rein them in?
Well, it wasn't entirely out of the blue. Several justices, especially in the majority, had already voiced concerns.
Right, they'd expressed discontent before.
Yeah, a feeling that some lower courts were maybe overstepping, exceeding their authority with these nationwide orders.
And Justice Barrett wrote the main opinion.
She did. And her reasoning really lays out the majority's view quite clearly.
What was the core principle she highlighted?
She basically said, and I'm paraphrasing slightly here, that federal courts aren't supposed to be general overseers of the executive branch.
Okay.
And that if a court finds the executive acted unlawfully, the answer isn't for the court to then exceed its own power.
Interesting. So it's about staying within their own judicial lane, so to speak.
Exactly. It's a strong statement about the separation of powers and concerns about judicial overreach into executive functions.
Now, you mentioned a partial stay. What are the specifics there? What exactly did they limit?
Right. The details matter here. The stay was granted specifically for preliminary injunctions.
Those are the temporary orders, right, while the case is still going on.
Correct. To prevent harm before a final decision. But, and this is the key part, the stay only applies to the extent the injunctions are broader than necessary to provide complete relief to each plaintiff with standing to sue.
Okay, let's unpack that a bit. What does that mean in practice?
It means the lower court has to be much more targeted. They can grant that temporary relief, but only to the specific people or groups who actually brought the lawsuit and can show they're directly harmed.
Not just a blanket stop for the whole country, at least not at this early stage.
Precisely. The court is saying you've got to deal with the plaintiffs in front of you first. Move expeditiously with them.
And the immediate impact. You mentioned the birthright citizenship executive order.
Yeah, that temporary hold that was stopping federal agencies from even planning how to implement it, that's now lifted.
Ah. So the administration can move forward on that front.
According to the analysis we looked at, yes. They're seen as likely to prevail on this specific procedural point, allowing them to proceed with their plans, at least for now.
And looking bigger picture, you said these injunctions have been a major hurdle for the administration.
Oh, absolutely. Described as having plagued the administration in its second term, they've effectively been freezing policies, programs all across the country, sometimes based on one ruling.
So, yeah, you can see why this decision would be seen as good news from their perspective.
Definitely. It gives them more leeway to actually implement policies without facing these immediate nationwide roadblocks from potentially a single judge.
Okay, so that's the majority view and the practical outcome. But a 6-3 decision means there was significant disagreement. Let's talk about the dissent.
Right. And the dissenters were Justices Sotomayor, Kagan, and Jackson. Sotomayor wrote the main dissent.
And Jackson followed a separate one, too.
Yes. But Sotomayor's main point, her big worry, was about creating what she called a patchwork of rights.
A patchwork. What does she mean by that?
Her concern is that if a district judge in one state blocks an executive action, but a judge elsewhere doesn't or can't issue a nationwide block,
you end up with different rules in different places.
Exactly. She is a pretty striking example, asking if a child born in New Mexico would end up having different rights than one born in New Jersey because of conflicting local court orders.
That's a powerful image.
Yeah.
So was she just criticizing, or did she suggest another way forward?
She did offer an alternative. She basically advised parents or others affected by such orders to quickly file class action lawsuits.
Class actions, instead of relying on one judge's broad injunction.
Right. And she urged them to ask for temporary relief for the whole potential class while the court decides whether to certify it as a class action.
And she had a message for the lower courts, too.
Yeah, she urged them to act swiftly on those kinds of requests. The goal seemed to be to try and avoid that patchwork problem.
And maybe get the underlying issue, like birthright citizenship in this case, back up to the Supreme Court faster.
Precisely. Get it decided on substance, not just tangled up in these procedural fights over injunctions.
The language in her dissent was apparently quite strong.
Very strong. One quote that stood out was, "Today the court abdicates its vital role. The president has made a solemn mockery of our Constitution. Rather than stand firm, this court gives way."
Wow. That really shows the depth of the disagreement there.
No question about it. A fundamental clash over the court's role and the right way to handle these challenges.
Now, interesting point from the sources, even Sotomayor's suggestion, moving towards class actions. That's still seen as a win for the administration. Why is that?
Well, it comes down to how class actions work. They're seen as much more rigorous and regulated than these broad nationwide injunctions.
Harder to get off the ground.
Generally, yes. There are strict rules for certifying a class, proving everyone in the group has similar enough claims that their representatives are adequate. It's a higher bar.
So it's a slower, more complex process compared to one judge issuing a sweeping order quickly.
Exactly. So even shifting to class actions likely slows down challenges and makes them potentially harder to win on a broad scale compared to the previous injunction landscape.
Okay, this historical context you mentioned earlier is really striking. Let's circle back to that, because this matters for you, the listener, to understand the significance.
Right. The fact that we went nearly 200 years.
Almost the entire history of the U.S.
Without a single one of these nationwide injunctions, it really puts their recent rise into perspective.
So when did they start becoming more common? Was there a specific trigger?
It seems to have really picked up steam maybe in the last 10, 15 years or so, often tied to challenges against broad executive actions, especially immigration policies, healthcare, things that affect the whole country.
And probably fueled by increasing political polarization.
That seems likely, yeah. They became this powerful, very quick tool for opponents of an administration's policies. But as we've seen, that also raised alarms about judicial power.
Which brings us back to the core issue. What does this mean for the balance of power?
Well, think about it. A nationwide injunction isn't just a court telling the specific parties, you do this, you stop that.
Is one court making a decision for everyone?
Right, making a decision for the whole nation, potentially stopping a policy enacted by the elected executive branch.
Even though the judiciary is meant to be the non-political branch that doesn't answer to the people, as our sources put it.
Exactly. So this ruling fundamentally redraws the lines a bit, changes the tools available for challenging federal policy on that kind of immediate nationwide scale.
So wrapping this up, the key takeaway for you is pretty clear. This wasn't the landmark birthright citizenship ruling many expected.
Not at all. It was a very significant move, but focused squarely on limiting this specific type of judicial power, the nationwide injunction.
A power that's actually relatively new in the grand scheme of things.
Right. And the decision makes it much harder to launch those broad, swift challenges that can freeze federal policy instantly across the entire country.
Which leads to a final thought, maybe something provocative for you to consider.
Okay.
How is this actually going to play out? We have this ruling limiting nationwide injunctions. We have Justice Sotomayor urging swift class actions.
Right. Will that actually happen? Will we see a flood of these more targeted but maybe more complex class action suits?
Could that ironically create the very patchwork Sotomayor warned about, just through a different legal mechanism? Or will it simply slow things down?
Slow down challenges, give the executive branch, whichever party is in power, more breathing room to implement policies before courts fully weigh in.
The really interesting question about this ongoing, dance or maybe tug of war
Yeah.
between executive power and judicial oversight.
Definitely something to watch and think about as this continues to unfold.